Welcome back to the verdict room. I'm your host, and today we're stepping inside the most controversial space in the American criminal justice system, the interrogation room. This is where careers end, where lives are destroyed, and where the line between justice and injustice becomes dangerously blurred. For decades, what happened behind closed interrogation room doors remained hidden from public view. No cameras, no witnesses, just a suspect, a detective, and hours of questioning. But in the last 20 years, something has changed. Exonerations have skyrocketed, wrongful convictions have been overturned, and the blame often points to one culprit: coercive interrogation tactics that pressure innocent people into confessing to crimes they didn't commit. Today, we're exposing 5 cases where aggressive police questioning crossed the line and destroyed innocent lives. Let's start with a question that might seem simple, but it's anything but. If you're truly innocent, why would you ever confess to a murder you didn't commit? The answer is more disturbing than you might think. And it happened to a man named Henry Lee McCollum in 1983 in North Carolina. Henry Lee McCollum was 17 years old when Sabrina Bowie, a 9-year-old girl, was brutally murdered in Robeson County, North Carolina. The community was devastated. The pressure on police was immense. Detectives needed a confession, and they needed it fast. What happened next in that interrogation room would haunt McCollum for the next 3 decades. McCollum was brought in for questioning. He had an intellectual disability with an IQ estimated at around 72. He was a minor. He had no attorney present, and he was alone with experienced interrogators who knew exactly how to break him. Hour after hour, detectives employed a tactic known as the Reed technique, a method of interrogation that essentially assumes guilt and uses psychological manipulation to extract a confession. Here's how the Reed technique works. Detectives confront the suspect with evidence, sometimes real, sometimes fabricated. They minimize the crime, suggesting it wasn't that serious. They offer psychological escapes, suggesting the suspect acted in self-defense or that it was an accident. They appeal to morality. They tell the suspect everyone knows they did it. And crucially, they use the power imbalance in the room. The detective has all the authority, all the information, and all the control. In McCollum's case, detectives told him they had evidence he didn't have. They told him that cooperating was his only way out. They painted a picture so vivid, so detailed, that McCollum, desperate, confused, and intellectually unable to fully grasp what was happening, eventually said what they wanted to hear. He confessed. But here's the devastating part. Everything McCollum confessed to was wrong. The details didn't match the crime. The timeline was impossible. The evidence didn't corroborate his statement. But McCollum was convicted anyway. He spent 31 years in prison for a crime he did not commit. It wasn't until 2014 that DNA evidence finally exonerated Henry Lee McCollum. 31 years. Think about that number for a moment. A teenager with an intellectual disability was interrogated without proper legal representation, broke down under pressure, confessed falsely, and lost 3 decades of his life. In 2014, he was finally freed. The real killer was never prosecuted because the statute of limitations had expired. McCollum was awarded $750,000 by the state of North Carolina, a settlement that can never truly compensate for 3 lost decades. But Henry Lee McCollum is far from alone. Let's move to our second case, the videotaped confession that should have been a smoking gun, but instead became Exhibit A in how police can manufacture guilt. In 1989, in a small town in Ohio, a woman was murdered. Investigators focused on a suspect named Keith Doucette. During an interrogation session, detectives presented Doucette with a theory. He had killed the victim. They questioned him repeatedly. They suggested he was protecting someone. They implied that cooperation would go easier on him. Over hours of questioning, Doucette's resolve broke. Eventually, Doucette confessed. And here's where it gets critical. The confession was videotaped. You would think that concrete video evidence would ensure justice, right? That a jury would see exactly what happened in that room and make an informed decision. The problem is this: juries don't always understand what they're watching. They don't see the psychological pressure that built over hours. They see a final confession and assume guilt. Doucette was convicted. But decades later, when attorneys reviewed the tape more carefully, watching not just the confession, but the hours of questioning that preceded it, they saw something alarming. The detectives were feeding Doucette information. They were correcting him when he got details wrong. They were essentially telling him what happened, and he was simply repeating it back to them. Worse, physical evidence contradicted the confession. But by then, the confession had already poisoned the jury pool. It took years of legal appeals, expert testimony from interrogation specialists, and DNA evidence to finally overturn the conviction. Doucette had spent years in prison based on a coerced confession that should have never held up in court. Now, let's pause and understand what's actually happening here. A confession is supposed to be the most damaging piece of evidence against a suspect. In theory, why would an innocent person ever confess? But in practice, something profound happens in an interrogation room. It's not just about being tough or weak, it's about psychology. When a person is interrogated for hours, especially without legal representation, their cognitive function breaks down. Their sense of reality becomes distorted. Studies by the Innocence Project, the organization dedicated to exonerating wrongly convicted people, show that false confessions play a role in approximately 30% of wrongful convictions. 30%. That's extraordinary. And it's largely driven by aggressive interrogation tactics that are still legal in most of America as of 2026. The tactics are varied and sophisticated. There's the minimization tactic. Everyone makes mistakes. You must have been in the wrong place at the wrong time. There's the maximization tactic. The evidence is overwhelming. Everyone knows you did this. There's the false evidence ploy. Detectives tell suspects that DNA, fingerprints, or witnesses place them at the scene even when that's not true. There's the Mutt and Jeff routine. One detective plays the good cop, sympathetic and understanding, while the other plays the bad cop, aggressive and accusatory. Together, they create psychological pressure that can push an innocent person to confess just to escape the interrogation. Let's look at our third case, which became a turning point in how Americans understand the Reid technique. This is the case of Brandon Moon in Illinois. In 2004, a murder occurred in Chicago. Brandon Moon, a young man with no prior criminal record, was brought in for questioning. Detectives suspected him based on what turned out to be faulty witness identification, a notoriously unreliable form of evidence that we could spend an entire video on. During 12 hours of interrogation, detectives employed classic Reid technique tactics. They told Moon they had evidence they didn't actually have. They isolated him. They told him his only hope was confession. Moon eventually confessed. He was convicted. He spent years in prison. But here's what made his case different. The entire interrogation was recorded, and when his attorneys reviewed that recording with expert witnesses, they could point to specific moments, timestamp by timestamp, where detectives fabricated evidence, made false promises about sentencing, and applied relentless psychological pressure. Moon's case became a landmark in demonstrating exactly how the Reid technique can produce false confessions. When he was finally exonerated in 2012, it sent shockwaves through the legal community. Police departments across the country began re-evaluating their interrogation protocols. Some adopted new standards, some doubled down on the old methods. Move forward to our fourth case, and we see a tactic that's particularly insidious: the leverage strategy. This happened in Massachusetts with a man named Sean Drummond. Drummond was arrested for a serious crime. Detectives had circumstantial evidence, nothing conclusive. But during interrogation, they employed a tactic that's both brilliant and deeply troubling from a justice perspective. They threatened Drummond with additional charges against his family member. They suggested that if he cooperated, the charges against his relative might disappear. This isn't just psychological pressure. It's coercion on a different level. They're not just threatening the suspect, they're weaponizing the suspect's love for family. Under this kind of pressure, Drummond confessed. He was convicted. It took years and multiple appeals to get his conviction overturned, but when it finally happened, it highlighted a critical gap in interrogation law. Threatening collateral consequences, charges against loved ones, job loss, custody issues, is a form of coercion that can invalidate a confession, yet it remains alarmingly common in interrogation rooms across America. Our fifth case brings us to the timeline trap. This happened in Nevada with a woman named Dina Schlosser. Detectives presented her with a detailed timeline of events. They suggested that her movements on the day of the crime placed her at specific locations. They used her own uncertainty, normal human uncertainty about what you did 6 months ago or a year ago, against her. They essentially told her what happened, and through hours of questioning, they convinced her to accept this narrative as her own memory. What's particularly disturbing about the timeline trap is that it exploits human memory. Memories aren't videos, they're reconstructions. They're malleable. When a person is interrogated for hours, when they're isolated, when they're desperate to escape, their memories can be rewritten. Detectives can plant false memories. They can suggest details so confidently that the suspect begins to believe them. And crucially, once someone confesses to a detailed timeline, that confession can seem incredibly credible in court, even though it's completely false. Schlosser spent years fighting her conviction. Expert testimony on false memories and suggestibility played a critical role in finally getting her case overturned. Her story became a cautionary tale about how interrogation tactics don't just pressure confession. They can actively create false memories that feel entirely real to the person experiencing them. Now, here's the critical question. What's changed since these cases? We're in 2026. What protections exist now that didn't exist before? The answer is both encouraging and inadequate. Several states have adopted mandatory recording of all custodial interrogations. This is huge. When the entire interrogation is recorded from start to finish, juries can see exactly what happened. They can see the pressure, they can see the tactics, they can see whether promises were made or threats were issued. 14 states now have statewide policies on recording interrogations. That's progress, but it's still only 14 states. 36 states don't have comprehensive recording mandates. Some jurisdictions have abandoned the Reed technique altogether, adopting instead the PEACE model, developed in the United Kingdom. PEACE stands for planning and preparation, engagement and explanation, account, closure and evaluate. Instead of assuming guilt and breaking down the suspect, PEACE-trained investigators gather information collaboratively. They explain the evidence and allow the suspect to respond. The goal is truth-seeking, not confession-seeking. Early studies suggest that PEACE-trained interrogators actually get more reliable confessions and more useful investigative information, while generating fewer false confessions. But here's the reality. As of 2026, the Reed technique is still taught in police academies across America. It's still the dominant interrogation method. Reform has been frustratingly slow. Police unions have resisted regulation. And the Supreme Court has been reluctant to impose strict limits on interrogation tactics, leaving the door open for aggressive questioning as long as Miranda rights are technically read. The human cost of this resistance to reform is staggering. Every wrongful conviction represents not just an innocent person destroyed, but also a real killer walking free. Communities never get justice. Victims' families never get closure. Real criminals continue to commit more crimes because they were never caught. When Henry Lee McCollum was finally exonerated in 2014, the real murderer was never identified. When Brandon Moon was freed, police resources had been wasted on prosecuting an innocent man, instead of pursuing actual suspects. When Sean Drummond's conviction was overturned, years had passed where the real killer remained unknown. The interrogation room is supposed to be a place where truth emerges. Instead, in case after case, we see it become a place where innocence is destroyed and guilt is manufactured. The tactics we've discussed today, false evidence claims, minimization and maximization, threats, timeline suggestions, family leverage, are still happening in interrogation rooms across America right now, tonight, while you're watching this video. The question before the legal system isn't whether these tactics can produce confessions. They clearly can. The question is whether a confession extracted through psychological coercion is actually justice. Whether a system that pressures innocent people into admitting crimes they didn't commit serves the interests of truth or merely serves the interests of case closure. As we move forward in 2026, the movement for interrogation reform continues. More states are adopting recording requirements. More police departments are exploring alternative interrogation methods. More juries are becoming educated about false confessions. But change is incremental, and every day interrogations happen without video recording, without proper legal representation for suspects with disabilities or mental illness, without understanding of how these tactics manipulate memory and psychology. The 5 cases we've explored today represent thousands of others. They represent the hidden cost of aggressive interrogation tactics. Innocent lives destroyed, real criminals left free, and a justice system that sometimes prioritizes confession over truth. So here's my question for you. When you think about interrogation tactics, do you think about effectiveness, or do you think about justice? And more broadly, in a country that claims to value innocence until proven guilty, should tactics designed to break down psychological resistance ever be considered acceptable? Tell us in the comments below. What's your verdict on police interrogation reform? And please subscribe to The Verdict Room so you never miss a deep dive into the cases and legal issues that define our justice system. We're covering everything from wrongful convictions to police reform to landmark Supreme Court decisions. You don't want to miss it. Thanks for watching, and we'll see you next time.